Hi, I'm Annie Fitzsimmons. I'm your Washington Realtors Legal Hotline lawyer, and this is another episode in our series entitled Thriving Through an Audit. And brokers, we are about to talk about earnest money receipts, communications around earnest money, all of this stuff that is probably the number one auditing issue. And if your firm has an auditing problem with respect to earnest money, I guarantee you it's going to come back to you. So please listen up to our special guests, Bill Dutra and Cathy McDonald. Who are you two?
Hi, my name is Bill Dutra. I work with the Department of Licensing. I work with our Business and Professions Division, where one of the many fun things I get to do is work with our licensing partners like Washington Realtors and speaking to brokers today.
And I am Cathy McDonald. I am the audit supervisor for the real estate program.
So when you talk about thriving through an audit, it originates with Cathy. So, Cathy, I'm going to just ask you. Earnest money is a broad topic with respect to auditing. Well, what's on your mind when I raise the question of earnest money? Where do you go?
I go all over the place. It's probably one of the most common findings we cite on an audit, whether it be late earnest money delivery or missing earnest money receipts. It's a common thing that we see on a daily basis. So as far as receipting, what's required is that there is a receipt held in the files and shared with the cooperating offices. You're also expected to keep your client informed of the status of the earnest money. So whether or not it's been, deposited with the holder of the money, or whether or not maybe it hasn't been deposited or according to the terms of the agreement. So we expect to see a receipt in the file from the firm if the licensee or anybody at the firm touches that money. And then secondarily, we need to see a receipt in the file from the holder of the earnest money. So we call it an earnest money deposit receipt, but it isn't really a deposit. It really is delivery. So in most cases, there is a third-party holder, whether it be escrow or whether it be an attorney's office that's holding that money. And you need to have in your file the receipt that shows that you delivered it to the holder of the earnest money. And they will hold that money then, obviously, till the closing of the sale. But that's what we look for when it comes to the receipting aspect of it. So there's a couple different parts of it. It might be the receipt from the firm because the licensee took it to escrow, or it may just be the receipt from escrow because the customer delivered it themselves.
Okay, so let's break those down. And I do not believe that very many brokers today actually receive earnest money from a buyer. Is that a true statement?
I would say it is much less than it used to be. We do still see it. We'll see it in correspondence. Sometimes we'll come across that in an audit. It'll say right in there that they received it, but then they don't have a receipt. So sometimes they will get a finding on their audit, from that because it was obvious they did handle it, but they don't have a receipt from when they received it from the customer.
Okay, so number one issue, brokers, if you actually touch a buyer's earnest money, in whatever form that might mean, you actually have physical control over their earnest money for even an instant in time, you must give a receipt to the consumer, to the buyer, and you have to retain a copy of that receipt in your firm's transaction folder. And you must deliver a copy of that receipt to the broker on the other side of the transaction. Is all of that true?
That is true.
Okay. To the extent you can avoid touching earnest money, that would be what I would encourage you to do. Don't touch a consumer's earnest money. And it's very easy in today's world to avoid touching a consumer's earnest money, starting with the way that the form is now drafted. The form, the statewide form purchase and sale agreement contemplates that buyer's earnest money will be delivered to escrow or to whoever the holder of the earnest money is. Most cases it is an escrow company that's holding it. So for the purposes of this video, let's just assume that an escrow company is going to be holding that earnest money. The statewide purchase and sale agreement says that the earnest money will be delivered to the holder of the earnest money. And so the form in and of itself contemplates that broker, you can be out of that loop altogether and that buyer can deliver directly to the escrow company. Whether it's buyer hand delivering a check, mailing a check, wiring funds, making some kind of an electronic transfer, If broker's out of it, broker should not have a receipt showing that they handled the earnest money, right?
Yep.
Right.
Yes.
But every single firm, buyer firm, seller firm, must have proof of the escrow company's timely receipt of the earnest money. Is that right?
Yes.
Okay. And that can take the form of any kind of a communication from the escrow company to the broker, and that one broker might share with another broker. There's nothing magic about what that looks like, so long as there is evidence in the firm's transaction folder that escrow received the earnest money and when, right?
Yeah. Just
Okay.
need to see where it came from.
Okay.
And then obviously dates.
Let's say we have a scenario where buyer's earnest money is due on Monday, and by Monday it's going to be paid to the escrow company. Close of business on Monday, buyer broker finds out from buyer it didn't get delivered timely.
Certainly, that happens.
What is your expectation of the brokers in that transaction?
So the statute requires the brokers to use reasonable skill and care, deal honestly in good faith. They should be notifying their clients the soonest they can that the earnest money was not delivered. Per the agreement, it was not delivered. If it was due by close of business Monday and they have no notification, I would expect they'd be contacting that broker by Tuesday morning. They're probably calling Tuesday, that closing agent. Did you receive this money by close of business yesterday? It's a yes or no.
Okay.
If it's a no, contact your client.
Okay. So buyer broker learns that the earnest money was not timely wasn't delivered by Monday when it was due. Buyer broker needs to be communicating to listing broker, is what you meant by that, right?
Listing broker should also be contacting as well.
Seller,
Yes, but the listing broker should also be contacting that closing agent.
to find out for themselves. Okay, but let's take this step by step. Buyer broker has the information.
Yes.
You expect buyer broker to communicate to the listing broker.
We would expect them to communicate to their client first that there is no earnest money.
Okay. So buyer and buyer broker are going to have that communication that the earnest money delivery has failed. And buyer broker is going to let buyer know the significance of that to the buyer. And I'm going to tell you the significance of that to the buyer is that anytime earnest money is due but not yet paid, seller has the contractual right to terminate that transaction. They aren't required to terminate the transaction, and the transaction is not automatically terminated. But the seller has the unilateral right to terminate that transaction during the period of time when the earnest money is due and not yet paid. So the earnest money is late. Seller doesn't have the right to terminate the transaction before the earnest money is due, but once it's due, if it's not paid, until it is paid, in that window of time, seller has a unilateral right to terminate the transaction, which is why Department of Licensing says buyer and listing broker, buyer broker, listing broker, you have to have clear lines of communication. So buyer broker, you have to notify your buyer, and I would say before you get to that point, here's why it's so important that you make timely delivery of your earnest money. But as you say, Bill, it's Monday night. I just talked to escrow buyer and your earnest money's not there. What happened? And whatever answer there is, I wired the funds. I don't know why they didn't get there. Well, what time did you wire them? I wired them at 3:30 this afternoon. Well, that's why they didn't get there, right?
Certainly.
Okay, so we had that conversation buyer broker to buyer. You also expect buyer broker to reach out to listing broker, right?
Certainly, it could be, depending on how that contract is worded, that could be a material fact to that transaction. I mean, it may be all of the money. It may be everything at once, part of that. So you need to disclose the material facts to the parties to the transaction.
Okay, so buyer broker has to notify listing broker. And then to your point, listing broker really should already know because listing broker should have reached out to the escrow company to find out whether the earnest money is there.
Absolutely.
They both should be tracking.
They should both be tracking it. If they agree that a party to the transaction is going to do this, deliver it, which is fine and great. That's how the contracts are written. Both parties have a duty to their clients to ensure that this happened.
Okay, one more piece. You expect listing broker to reach out to seller and let them know that buyer's earnest money was not delivered timely, correct?
Yes.
Okay, so we've got buyer broker communicating with buyer, we've got buyer broker communicating with listing broker, we've got listing broker communicating with escrow, and we've got listing broker communicating with seller. Every bit of that communication must be documented in the firm's transaction folder. Is that correct?
Yes.
Okay. So when we talk about material correspondence being in a firm's transaction folder, would you consider this to be material correspondence?
Absolutely.
Yeah, for sure.
Okay. I have to follow up on a question that I get so often, Cathy, and I know you and I have had this conversation before. When earnest money is delivered late, let's say it's due on Monday, it doesn't get delivered until Wednesday. And we've had all of the communications, they're all documented, everybody knew what was happening, and seller said, that's fine, I'll give buyer the extra time, no problem. Once the earnest money is delivered on Wednesday, there is no requirement that the seller sign an addendum accepting or otherwise agreeing to the buyer's late deposit of the earnest money.
No, notification is all that's required. A change in terms is not required. It doesn't require an addendum or anything like that. We just need to see the notifications in the file and then the fact they move forward.
Okay. All right. Perfect. Earnest money seems like such a big topic. It doesn't seem like we could possibly be finished talking about it yet. Is there anything else that we need to say about earnest money from an auditing perspective?
I guess I'll just kind of reiterate what I said at the beginning of this. It's for some reason, late earnest money delivery and missing earnest money receipts in all the years I've worked for the department have always been one of the number one findings we have on an audit. I don't know why. It's hard to make it happen like it should, but for some reason, it's what we see. It may not be the number one, but it is. If it's not number one, it's number 2 or number 3 on the list.
Yeah. I think that one of the reasons, this is just me hypothesizing, but earnest money comes at a point in time in the transaction when buyers and buyer brokers are excited about other stuff.
Yeah.
Right? We just formed this transaction 2 days, 3 days later, earnest money is due. But in that same time period, we're setting up inspections. We're making loan application. If we've got another house to sell, we're getting it on the market. We're calling our folks to let them know that we finally got a house to buy and we're so excited. We're trying to coordinate a time when we can bring the kids in to pick their bedroom. There's just so much happening. And then with electronic delivery, that delivery has to, if you're going to wire funds, buyer brokers, you've got to let the buyer know how important it is to set that process in motion sooner than the day that the funds are delivered. Funds don't get wired like that. Mm-hmm. And so that's really an important piece. And then I think another piece of it is that sometimes buyer brokers feel like, ooh, the buyer screwed up. They're going to be able to fix it by tomorrow. I'd rather not say anything and not highlight the fact that the buyer's late, especially if the seller has the right to terminate, especially in a market where sellers might have backup buyers, maybe a backup buyer who's paying more than my buyer. Probably in my buyer's best interest if I zip it and don't say anything and let the buyer pay their earnest money or deliver their earnest money. And if we can do that before the seller knows it, then phew, we made it.
It's possible, but as you said earlier, if that selling agent is doing their job as well, the seller knows that as soon as the buyer's agent knows that. They'll know at the same time. So get out in front of any potential issue that you might have and notify, document what is happening. Be transparent. I truly want to believe that most sellers, if you're honest with them and you have a good offer, they accepted your offer, be transparent with them. Things happen. Like you said, people are excited. They forget. There's a lot a buyer has to do the moment they say, you're under contract. Everybody loves that text message nowadays. You're under contract. You got it. Oh my, I've now have 5 days to get an inspection. I've got to do a neighborhood review. I've got to get the rest of my loan documents in. Right. Everybody wants money from me right now. And things can happen. Just be open and transparent to what happened.
Yeah. And I am not quite as optimistic as you are about all sellers out there. There are certainly sellers who will want to take advantage of a buyer's failure to deliver earnest money if they've got another backup buyer who's paying more, which is further illustration of the point that you made, Bill, which is listing brokers from your standpoint, you had better be contacting Escrow to make sure earnest money was delivered, because if you are representing that seller who has a backup buyer they'd rather do business with, this might be their only window in time to force a termination of that first agreement so that they can move the backup buyer into first position. And listing broker, if you miss that window on behalf of your seller because you didn't reach out to escrow, you might have a very narrow window. The earnest money might be due on Monday, and if it's going to be held at escrow, that means it really has to be there by close of business. Although the time period is 9 p.m. on the contract, it has to be there by close of business because escrow is closed.
Right.
Mm-hmm.
And buyer wired it, but it just didn't get there. Buyer's wire might reach the escrow company early the next morning, which means that seller's only window to terminate this purchase and sale agreement might be from 9 p.m. on Monday night until opening a business on Tuesday morning. Listing broker, if you haven't been reaching out to escrow to find out whether or not the earnest money is there, you can't communicate that to seller. Seller can't move forward to terminate that transaction and put the backup buyer in first position. That's why you care about this, right?
Yeah. It's really just for consumer protection, and different lawyers will tell people different things on how to handle that. So it's as far as not from a licensee standpoint, but from like a buyer's standpoint as to whether or not they want to try and keep that under wraps. Sometimes they'll say, absolutely do not notify that it's late, or, so it's difficult for a consumer if they're out there and they're in a competitive market.
And they're exposed.
Mm-hmm.
They're exposed.
But you can't address what a buyer's instruction is.
Nope.
You can only address what a licensee's obligation is.
Yes.
Yeah, and sometimes they aren't the same thing.
If you have questions on this topic or any other, please ask me a question by visiting warealtor.org. Thank you for being a Washington Realtors member.